Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video, I'm going to try to go over California misdemeanor arraignments. This is going to be a criminal defense, criminal procedures sort of video. As of right now, this is only this is my first one, basically. Like in the future, I might have additional criminal defense, slash procedure sort of videos. This is my first one though, so we'll see how it goes. So the reason why I wanted to give this kind of, a try, I suppose, is I go to criminal court not every day, a couple times a week, I guess. It is not the dominant practice area that I have, but I go there often enough and I see a lot of defendants basically facing misdemeanor charges who, for lack of a better word, are completely clueless about what's going on. And I'm sure there are exceptions to this, but I would struggle to kind of come up with good reasons, examples of areas in life where it pays really to be uninformed, particularly when it comes to court and you're facing a fine, jail time, a criminal record, etc. There really is no reason, I think, to be kind of uninformed about the process. Now, not every criminal defendant is uninformed. If you have your own lawyer, hopefully your lawyer is doing a good job of explaining things to you. But the vast majority of defendants who either don't have a lawyer or who have the public defender, for instance, there really just is not the time to really explain the process, I guess, to the defendant one-on-one. The public defender, for instance, just does not have the time to actually do that. And again, I guess I just go back to the fact that, if you're facing charges, if you're facing a fine and jail time, there really is no good reason why you should be uninformed. Hopefully this video helps. So anyway, all of that background stuff said, let's go ahead and try and get started. So in my experience, misdemeanor arraignments in California generally go over, well, I guess in the worst case, probably five different areas. Not every area is going to be present in every case. I'll explain as we go. So of the five areas, number one, I think, is going to be advising the defendant of what rights they have. Number two is going to be reading the complaint. That may or may not happen depending on the situation, but the reading of the complaint, can happen. Number three is getting court-appointed, counsel, getting a court-appointed attorney. There you go. So again, that may or may not happen depending on the case. It might be necessary, it might not be. Number four is going to be entering the defendant's plea. And number five is going to be, bail release or an own recognizance sort of release. So those are the five areas. Not every area is going to be present in every case. So for a couple of them, if it's talking about, court-appointed counsel, if you're a defendant and you have your own lawyer, obviously the court is not going to worry about that stuff. So that's not going to pop up during the course of your particular arraignment. So anyway, let's go ahead and try and get started. If this video gets to be too unwieldy, I'm going to go ahead and put time codes down below. If you're only interested about appointment of counsel, let's say, watch from here to here. If you're only interested in the plea part, from here to there, etc. So, we'll see how it goes. Anyway, so the first area that we're going to talk about is the advisement of the defendant's rights. So, if you are in California, there's going to be some parts of this that will vary slightly depending on how your county happens to do it. California law is obviously, the same all throughout California. So the substance, the idea of what I talk about should be the same regardless of county. If you happen to live outside of California, what I talk about is probably going to apply in a very, 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 very general way to you. I guess in the United States, the rights that a criminal defendant might have, the procedure and so forth, a lot of it's dictated by state law, but a lot of it is federal also. And obviously, if you live outside California, but in the U.S. somewhere else, then federal law will apply to you anyway. So hopefully that made sense. So anyway, back to number one. So it's the advisement of the defendant's rights. By my count, there's generally going to be 7 rights that the criminal defendant in California facing misdemeanor charges will have. I'm going to try and see if I can fit all of them over here, but if not, I might try to, paste and link them down below, for instance, depending on what room I have. So anyway, so the first right generally is going to be the right to an attorney. So mean, I'm going to talk about this more later on when I talk about court-appointed counsel, but the right to an attorney is one. If you want to look over all these rights, they're going to be in the California Constitution, specifically Article 1, Section 15, which I will try my best to link down below, I guess, again, depending if I have room. But anyway, so the right to a court-appointed attorney is number one. The right to a speedy and public trial is number two. There's going to be deadlines for that. To keep things simple, I'm not going to go into that, but if you want to look up, let's say, Penal Code Section 686, 1382, etc., those deadlines will be specified there. The third one is going to be the right to a trial by jury of one's peers. That one you've probably heard of before, but in California there actually is case law, for example, that says that that is a defendant's right. The fourth one is going to be processes of the court, the right to use the court for your defense. That one's a little harder to explain. The basic idea, I think, is going to be that the defendant has the right to use the power of the court to help them prove their case. The best example that comes to mind, the most common one, is that if you are a defendant and you know that there are witnesses out there who will exonerate you, for instance, if you ask them and they say, hey, I really don't want to get involved in stuff, you can use the court's power to compel them to come testify on your behalf, for instance. So the court won't help you, but it at the same time will, I suppose, if that sort of makes sense. But court processes, you have the power to, or you have the right to use court processes in your defense. The next one, which I think is number 6, possibly 5 or 6, is basically you as a defendant have the right to confront and cross-examine witnesses against you. So, for instance, let's say that you are facing misdemeanor, robbery charges, let's say, and suppose that the police have a witness who says that they claim to have seen you use a knife to rob this person, and you have the ability to confront this witness, cross-examine them, to make sure that, or to elucidate, I guess, for the court, that, for instance, this person really could not have seen what they claim to have seen, for instance. So you have the power to do that. The next one is going to be the right to remain silent. In California, that's Evidence Code Sections 930 and 940. If you have seen the Miranda warning on TV, you have the right to remain silent. Anything you say can and will be used against you. That's basically there also. The last one, which I will talk about more later on when I talk about bail and OR release, is that a criminal defendant facing misdemeanor charges in California has the right to release on reasonable bail in most instances. In terms of penal code sections in California, that's 1271 and 1458. So hopefully all of that sort of makes sense. Those rights, this is one area in which the counties in California will differ. Some counties, for instance, will actually have the judge advise each defendant kind of individually that way. Some counties that are bigger, that have more cases, fewer judges, etc., a lot of times they will have defendants basically, advised in mass. They'll basically tell you all this stuff in a group via videotape, audio tape, etc. So hopefully that made sense. That's number 1, advisement of defendants' rights. One of 5 sections we're going to talk about. Number 2 is basically going to be the reading of the criminal complaint for the defendant. I have never actually seen this done, to be honest. Reading of the complaint is literally what it sounds. The judge in the court will read it to you. If you are the defendant and you have your own lawyer, almost every lawyer that I've ever seen will waive the reading. It's just not necessary. If you're a lawyer, you can read the complaint yourself. You don't need to have the court or the judge read it to you. The idea basically is that if, for instance, a defendant is illiterate, doesn't speak English or something, they really can't read the complaint themselves. They might get stuck on the language, not understand terms, etc. If that's the case in your situation, the idea is that if the court reads the complaint to you, you'll be fully kind of aware of what charges you're facing. So in general, though, I have never seen it done. It's something where everybody just reads it themselves. So on the topic, actually, of defendants who don't speak English, in the California Constitution, actually, if you don't speak English, you are actually entitled to a court-appointed interpreter also. That's Article 1, Section 14. So anyway, so that's number 2, the reading of the complaint. Number 3 is going to be the appointment of counsel. Again, if you've seen the Miranda warning on TV before, you've seen you've heard the warning like, okay, if you cannot afford an attorney, one will be provided for you, blah, blah, blah. So earlier on in the video, I also mentioned that federal law applies here also. So under the U.S. Constitution, this is the Sixth Amendment right to counsel. So I guess lest any of you think that, the right to counsel is, without restriction, I suppose, the courts in California are actually authorized to inquire into the financial status of a particular defendant to see whether or not they really are, indigent, or they really are, suited, I guess, for public defender representation. And that's Penal Code Section 987C, in case you're interested. But yeah. And the courts in California can also make a defendant, possibly pay back the cost of the public defender at the end of the case, if that defendant actually does have the means to do it. Yeah. So in the same sort of idea as appointment of counsel, there's the idea of waiving counsel also. In California, that's called the Ferretta waiver. Ferretta is F-A-R-E-T-T-A. It's a case in California where this idea sort of started. So under the Sixth Amendment, you are actually able to waive your counsel and proceed on your own in a criminal defense sort of scenario also. Whether or not that's a good idea, maybe, maybe not. Each case is different. But the idea behind waiving your right to counsel, however, is that, number one, it has to be something that you are doing voluntarily, you're aware of the consequences, it's intelligent, knowing. You just can't waive it randomly. Like, you actually have to be pretty purposeful, you have to know what you're doing, etc. when you decide to waive. Number two is that if you are going to waive your right to counsel, it's something where you have to waive it unequivocally. You can't just sort of, be half-hearted, I guess. You have to be very clear. Yes, I want to waive. No, I don't want to waive. Like, to use language that's sort of in the middle, like this, really is not helpful. You need to be very clear. And lastly, there's a time requirement. You have to waive your right to counsel kind of within a reasonable amount of time prior to trial. So that's the Ferretta waiver. And that's the appointment of counsel sort of section. So number 4, I think what we're up to, is basically bail or own recognizance release. So I don't know if this will surprise any of you, but if you are charged with a misdemeanor in California, you are not necessarily in police custody or in jail sort of custody when that happens. Some people who are arrested for misdemeanors are actually released prior to their arraignment, for instance. So if that's the case, and obviously bail or release really is not that big a deal. If, however, your particular situation results in the court or the prosecutor, whoever, wanting you to stay in custody, that's more kind of what I'm talking about now. If you are in custody for a misdemeanor offense that you're facing, then it's Penal Code Section 1270 that basically says that you are generally entitled to either to a own recognizance release, like basically to let you out with a promise that you won't do anything bad, that you'll come back to court, etc. Or later on, you can also seek a bail sort of release if you want. I'll talk about bail in just a second, but the basic idea is that if you're in custody, you're facing misdemeanor charges, you are generally entitled to an own recognizance release. If the situation in your case really makes that kind of an unwise sort of idea, like if you get released, you'll flee the country, or you'll hunt your victims and kill them or something, the prosecutor does have the right to ask the judge to deny you an OR release. If that's the case, public safety, is going to be the basic idea, the basic rationale. If for whatever reason, the judge decides to grant that, maybe there's a bail argument that can be made by your attorney also. So on the topic of bail, right now it's like mid 2018. Bail is kind of in flux right now. Like there's a lot of talk about how the bail system is basically discriminatory against the poor. How bail really is not tied to public safety. It's tied to basically how rich the defendant is. Currently, at least, a lot of California counties will have bail schedules. So the thing is, for a given offense, there's going to be a kind of set amount for whatever bail is, 50 million, 10 million, 1,000, whatever. So the bail schedule for Santa Clara County, at least, I'm going to go ahead and link that down below. So go ahead and take a look at that if you want to, if you're interested. But if you are denied an OR release, for example, your lawyer might argue under, I think it's Penal Code 1289, that you are entitled to, reduced bail. 1289 also allows for the prosecutor to argue for increased bail if the situation sort of warrants it. So one thing about the OR release thing, which I guess some of you might be wondering, if you are charged with if you're charged with a domestic violence related sort of offense, there is an exception under Penal Code 1270.1 rather A, where if you're charged with one of the listed DV related offenses, you generally are not entitled to automatic kind of OR release. There has to be a hearing. The DA will probably argue that you should not be OR released, blah, blah, blah. So OR release, the entitlement in a DV related situation is not nearly as straightforward, I suppose. So what else? I think that's it for bail and OR release. The last part I'm going to talk about, number 5, is basically entry of the defendant's plea. Now, if you're the defendant and you're ready to plea at your arraignment, you certainly can. A lot of times, if the case is somewhat complicated, you might not want to plead right away. Maybe, you want to have your lawyer do some more discovery or something. But there's a logic behind why you should plead early, whether or not you can plead early, etc. But if you're kind of interested in the plea-related sort of statutes, that's Penal Code Section 988, 989, 990, in that sort of range. So I will tell you actually that a lot of times people, or defendants rather, to be specific, defendants facing misdemeanor charges will generally try to plead no contest. I'm not sure if they really understand why they should plead no contest or shouldn't. I don't think they understand what it means. If you plead no contest to a misdemeanor charge in California, the next thing that will come out of the judge's mouth basically is a statement that, and sir, you understand that pleading no contest is the equivalent of pleading guilty. So in criminal court, no contest and guilty are the same thing. The only kind of difference is that, no contest basically means that later on in a civil suit, your criminal kind of, case cannot be used against you. In some instances, if you are likely to be sued for whatever crime you committed, maybe that's beneficial. In some cases, if the likelihood of a lawsuit is very low, you can plead no contest. It really doesn't buy you anything, I think. But the basic idea is going to be that if you decide to plead no contest, or if you decide to plead anything, no contest, guilty, etc., then it's something where the judge has to make sure that, number one, you understand what you're doing. You're doing this, willingly, voluntarily. You understand the pros, the cons. Generally, you're going to have to give up certain rights also in order to plead. So you're going to give up the right to a jury trial, the right to confront witnesses. The judge has to basically, make sure you understand that too. If you're interested in that, I guess the case for that is there's a case, a U.S. Supreme Court case called Boykin, Boykin, that goes over kind of I guess the plea process, knowing voluntary, that kind of thing. The last thing that kind of comes to mind actually is that if you decide to plea to something, it's going to be a situation where you basically have to be advised of the direct consequences of your plea. So if it's something where, for instance, you are pleading no contest to a sex offense or something, or you're going to plead no contest to DUI, one consequence of that would be that you are going to lose your driving privileges or have them revoked or suspended or something. If you plead no contest to a sex offense, you might be subject to sex offender registration for the remainder of your life. Penal Code 290. So the judge has to kind of advise you of those things to make sure that you really are sure that you want to go ahead and you want to go ahead and make this particular plea. The one that I see actually the most, I don't know if this is California specific or Northern California specific or whatever, but I want to say it's Penal Code Section 1016.5, thereabouts, where the court basically will basically tell you that if you are in the United States, either on a green card or you're here without lawful status or something, by pleading no contest or guilty to this offense, that could trigger a lot of immigration sort of consequences. So if you're here, if you're a U.S. citizen, rather, pleading guilty or no contest really doesn't affect you a whole lot in this way. But if you are here on a green card, for example, having a conviction on your record could be something that prevents you from getting citizenship later on, could be grounds to not renew your green card. If you are here without lawful status, if you're illegal, undocumented, and so forth, if you have a conviction, that could be grounds for your deportation also. By law in California, judges cannot ask whether or not you're a citizen or not, but they basically give this warning to everybody. If you're here in the U.S., not a citizen, pleading guilty, pleading no contest could subject you to a lot of bad immigration sort of consequences. So hopefully all of that helped. This video was actually quite long, almost 21 minutes now. But the basic idea, kind of in quick summary, a criminal misdemeanor arraignment in California, advisement of the defendant's rights, reading of the complaint, oftentimes this is waived, you don't have to waive it, getting a court-appointed attorney in the situations that require it, discussing bail and or own recognizance release, and lastly, entering the defendant's plea, be it guilty or no contest, etc. So hopefully all of that helped. I don't mean to rush through this, but misdemeanor arraignments are not complicated, I guess, if you do them kind of with some frequency. But this video hopefully is going to be something that if you're facing charges and you watch this, it's going to be something that really helps you understand and not just be sort of deer in the headlights, sort of scared, I guess. So for all the stuff that I mentioned, or as much as I can fit down below in the description, I'm going to go ahead and link to statutes and code sections and so forth. So go ahead and take a look at that if you are trying to prepare for your arraignment, let's say. But so hopefully all that helps. Go ahead and share, comment, like, subscribe, etc. And I will talk to you guys next time. Thanks.